Ocala's information station, 1370 WOCA.
Ocala.
All right, we go from an author who sounded like an attorney to an attorney. John Fuller is in the studio. He's an attorney with the law firm of Fuller and Fuller, and this show is called Legally Yours. It is your opportunity to have some legal questions answered. If you have a question or just want to join in on whatever conversation gets started, the phone number is the WOCA Climate Control Source Hotline. It is 352 if you're out of the area, and then 622-9622, and the other Fuller at the law firm of Fuller and Fuller is Janet Fuller, and that's John's wife.
Good morning, Larry. Happy New Year.
Happy New Year.
Happy New Year to all our friends listening. I hope you, your family, and everybody listening had a good holiday season, and it's good to be back.
I have a question about courtrooms. I know this is so far to the extreme of what we ever talk about.
Oh, it's nice to start the year with something different.
But they all have
what our topic would be.
They
today.
all have a lot of carpentry work in them. Is there a reason for that?
No, I really don't know that there is any rhyme or reason. I think originally the theory was that people wanted to build courtrooms so that they would have a certain majesty to them, so that people would appreciate the seriousness of what was going on there.
That's probably true.
And bring the appropriate sense of focus and decorum, because really a trial is a very, very major event in the participant's life. And so I think that they need to do that. But I've tried cases in courtrooms that were built over 100 years ago, and they were absolutely majestic. And I've tried cases in more modern courthouses, and they looked sterile and very unattractive to me. And of course, I understand that beauty is in the eye of the beholder.
Right.
So it may not be. I will tell you a real quick, funny, anecdotal story. Is that when they were designing one of the additions to our what is called the Marion County Judicial Center, I think it was the second one, or it may have been just enlarging the original first courthouse that was there, that opened up in the 1960s, to try to get more room and build some temporary courtrooms just to wait to get through the crunch, because they were literally holding hearings in the hallway in that old building.
Oh, wow.
In the mid 80s, before they built the second edition. We're now on the third edition, but in any event, they hired an architect, and he was very talented, and he designed a very attractive courtroom, but he never talked to the judges and he never talked to the lawyers. And so he designed a courtroom that he thought was aesthetically pleasing, but in the jury box, he only provided seats for 5 individuals. Well, we don't have any five-person jurors juries. We have either 6-person jury or 12-person juries, depending on the nature of the case. And you usually always have at least 1, 2, or 3 alternates. Even more than that in big trials that may go on for weeks and months, because people may get sick or have family emergencies where a juror would have to quit sitting, and they would bring on an alternate, and the alternates sit there throughout the whole trial. They hear all the evidence, they hear all the opening and everything that goes on, they hear the closing, and then when the jury gets ready to go deliberate, then they are excused.
A theory I had about the wood was that it was for the acoustics, because before microphones and sound systems, you had to almost think of it in terms of a concert. If you wanted everybody to be able to hear everybody else.
That's a really good analysis, and I suspect and hope that maybe that did enter into it. But I have tried cases in courtrooms, both old and new, that had the worst acoustics that you could possibly imagine. I don't know that was really. If that was their goal, I don't know that they always achieved it.
Let's go to the phone. That's what your show is about, and everybody's invited to call John Fuller right now. The number is the WOCA Climate Control Source Hotline, 622-9622. Good morning. You're on the air with John.
Yes, good morning, Mr. Fuller.
Good morning. Happy New Year, sir.
And thank you, and you too. As a lawyer, what are the procedures to set up a court date? Are there fees involved, procedures, certain procedures, and can you kind of go through that a little bit with us?
To set up a what? I'm sorry.
A date in the courtroom, to set up a trial.
Oh, to schedule a trial?
Yes.
Well, assuming that the lawsuit has been properly filed, the opposing side has filed an answer, not just a motion to dismiss, but has filed an answer, and the case is what is called at issue. Then there is a procedure under the Florida Rules of Civil Procedure where either party, once the case is at issue, may file a notice of trial. It's called, and you advise the other side and the court, you send a copy of it to the judge's judicial assistant, that the case is at issue and is being noticed for trial. Now, the judge actually schedules the trial. He is in charge of his schedule. In the notice of trial, you will advise the court whether or not it is going to be a jury trial or a non-jury trial. You advise the judge about how many days you think it will take to try the case. And then thereafter, the court will usually set a case management conference or a pretrial conference in which he goes through and requires a pretrial statement to be filed. And he will then have the parties file statement of what the case is about, list of all witnesses, lists of all exhibits that are anticipated to be used in evidence. If it's a jury trial, jury instructions need to be prepared and submitted, and this pretrial order will spell out exactly what the judge wants you to do and the time frame in which you are to do it in. Different judges will use different pretrial orders. They will have different time frames, and that's their personal preference. But that is the way you schedule it for trial. Now, in a family law case, you've got one additional step, and that is you do not just notice that the case is at issue, but you must also state that it is ready for trial. So it can be at issue as soon as the pleadings close, which means you file your complaint, the other side files an answer. Technically, the case is at issue and can be noticed for trial. But if there's 10 depositions and a half a dozen other procedures that need to be completed, it is not necessarily ready for trial. So they want you to, when you say it's ready for trial, that you theoretically could go try it in the near future.
Is there ever a situation where the people involved, the lawyer like yourself and everyone, want to push it and have it done more quickly for whatever reason?
Well, certainly, there's cases where you want to move it forward as quickly as possible. Other cases, there may be reasons where it would not be something that you would want to necessarily move at a inordinately fast pace. For instance, someone in an automobile accident, and during the pendency of the trial, it's discovered that the individual will need additional surgery. You may want to have the trial actually continued or postponed until the outcome of that surgery is known. So I mean, every case is different.
Is there would there be like a penalty for canceling a court date?
Well, if the trial is set by the judge, the lawyers do not have the authority to cancel it, nor do the parties of their own accord. It would have to have court approval. Now, you could stipulate to a continuance, and then the judge has the discretion whether or not, even when both parties agree to a continuance, whether or not they will, the judge will allow that continuance. But that's discretionary with the judge.
If the situation carries on to a certain extent of time and it does get canceled, are you liable for some fees and stuff?
Well, I don't know exactly what you mean by canceled. If it just gets continued, that would not give rise to a claim for fees.
Yeah.
I don't believe, unless there was some allegation that the delay had been caused by some abuse of the system. If the case is dismissed, if the case is sitting there, and there's nothing filed of record with the case, and it sits dormant for a year, it can be dismissed for lack of prosecution. And then if it is refiled, it can trigger a provision that the side would have to pay the other side's cost if it was dismissed. Also, it can be very punitive if the statute of limitations has run and the case gets dismissed for lack of prosecution, then you can't refile it. If it just gets dismissed for lack of prosecution because it has sat dormant and neither party did anything for more than a year, nothing will stop the refiling of it. But you could, in those cases, be required to pay the cost of the other party in some instances.
I was kind of like thinking, like, let's say you're getting close to a trial date and the person involved, let's say, gets killed in a car accident or dies of a heart attack. Are the families involved in the case, or somebody involved? Do they have to pay a fee to?
No, that's an entirely different scenario. If a party to a lawsuit dies, in some cases the lawsuit dies with them. In some cases it does not die with them. The lawsuit will continue. In that case, you file a document which is called a suggestion of death, and then you have the personal representative of the party's estate appointed, and that party then stands in the shoes of the deceased litigant. But that depends upon the substantive law, and that gets very, very technical and really beyond the scope of a discussion that we would have on the radio. You would need to talk with your individual lawyer about that. But that's different than just letting a case sit dormant, or in getting a continuance, which is what I was anticipating or thinking about. If a litigant dies, then it's a whole different scenario, and it has to be analyzed in light of what kind of case it is, whether the litigant is the plaintiff or whether the litigant is the defendant.
Okay, well, thanks a lot for the
answer. Always good to hear from you. Thank you, sir.
You bet. Bye now.
Again, the number, if you'd like to speak to John, is 622-WOCA. That is the WOCA Climate Control Source Hotline to be part of the show. Once in a while you hear a news item that says somebody has a life sentence has requested a court to look at parole, the possibility of parole. And I don't know, sometimes they get it, I guess, right? But do they just do it on their own, or can somebody who's already incarcerated hire an attorney?
Well, yes. There's people who hire attorneys who are incarcerated to try to challenge their conviction. There are plenty of cases on the record where people have served 10, 20, 25-year sentences as an innocent person, and then after all that time, new evidence comes to light that completely exonerates them. Someone else confesses to the crime. They go back and are able now to do DNA evidence that they didn't have that technology at the time the individual was convicted, and there are an alarming number of cases where people have been convicted in jury trials and sentenced to death, sentenced to life imprisonment, sentenced to long sentences, and then many years after the date, new evidence comes to light, and there's provisions for allowing that to be reopened, and in many cases those people have been released after long periods of incarceration. Now, you mentioned the word parole, and that's a little bit different.
Two different things, okay.
The judge sentences, but once he sentences, absent new evidence or something like that, that pretty well ends the case at the trial level. The appeals run their course. If someone is going to be paroled or is eligible for parole, if it's not a very real serious offense, parole is established by the Department of Corrections based upon how much time you're sentenced to. The language in the sentence itself that you will be incarcerated for X amount of years and thereafter will be on probation.
Okay.
And probation and parole are two different things.
Okay.
Parole is when a person is let out of his sentence on an earlier than the original release date sentence. Or in certain criminal offenses where a party is sentenced for life. Some sentences, even though you're sentenced for life, are eligible for parole, and then some sentences are life without parole, depending upon the crime and depending upon what the sentence is. In that case, there's a parole board, and I'm really not familiar with how this works because I've not personally been involved with it. But a person, you read in the news like Sirhan, who was convicted of assassinating Robert Kennedy. He was sentenced to life. Well, in the state in which he was sentenced, he's been eligible for parole for many, many years, and he comes up for parole before the parole board, and they say, no, you're not going to be released, go back to jail, that sort of thing.
Now, in the high-profile cases like his, is a lot of the decision that, a lot of times, is the decision made because of high profile? There was a case just, I think it was this week, the teacher, the pretty blonde teacher that was with these boys having sex with them.
I saw that.
And she was asking if she could have her sentence done or something.
Was it termination of probation?
I think so.
I think that's it. Yeah,
I think so.
Yeah, I saw
and
that.
they told her no.
I saw that blurb too, and a lot of times you will have people, even without being incarcerated, who are placed on probation. And if it was a nonviolent crime, if the person demonstrates to the judge that they have been rehabilitated, that there's no longer any fear that they're a threat to society or to others or to themselves, what have you, you can ask the court for early termination of probation. Okay, the court has continuing jurisdiction over its probation sentence until the probation is either served, or if there's legitimate reason, and people get put on probation, and then after a period of time it appears that probation is no longer necessary, it's no longer warranted. The goals of probation have been fulfilled, the person has complied with all of the conditions of probation, and there's really, the probation officer has to recommend it, the prosecuting attorney has to not be opposed to it, the victim has to not be opposed to it, but you come forward and you show that there's no legitimate reason to continue the probation. It's an expense to the taxpayers, and so judges have been known to fairly, regularly, given the right circumstances, to grant early termination of probation. Now, generally, as a rule of thumb, early termination of probation does not take place until at least half of the probationary time has been served.
And so did the high-profile nature of her case, did that play?
I didn't read the article carefully, and I don't know what the denial was really based on in that case, other than there is a punitive component to probation, because you are certainly limited. Even though you're not in jail, you have conditions. You can't imbibe alcoholic beverages. You can't go out of the jurisdiction of the court without the permission of your probation officer. You have to have a curfew in many instances. It certainly has limitations while you're on probation that limits your freedom. In some cases, they have to wear ankle bracelets and so forth and so on. That there are GPSs that let you know where their location is, and so so there is a punitive aspect of it, that the person, even though they're not in jail, they don't have full freedom of movement, and that you or I or any other person who has never been convicted would enjoy. So it may very well be that the sentencing judge felt, no, I don't care if you're perfectly rehabilitated, you're married, you're a mother, you've gone to counseling, you've dealt with the issue, you're not a threat, you've been a model probationer, you've crossed all the T's, dotted the I's, you've paid your probation fee for the cost of probation, you've paid any restitution for the cost of the investigation of your case, you've done your community service hours, whatever may have been part of the condition.
Right.
You know, you've done all of those things, and you've done them consistently, and you've done them well, and you've done it for more than half of your sentence. It's still a discretionary call by the judge. And
now, boy, I hope I'm not stirring up something with this question, but what we're talking about kind of makes me think about Bernie DeCastro's case. Now, and maybe it wouldn't have been fair to bring this up while he was running for sheriff, but now that that's done, he was pardoned by the governor from a felony. He doesn't deny that he committed whatever it was that he was charged and found guilty of. But by being pardoned, it enabled him to be a free citizen without that burden of the felony.
Right.
In other words, he could run for office.
Right. Anytime a person is convicted of a felony offense, they lose their civil rights. They lose the right to vote, the right to possess a handgun, unless they're restored.
And they'll only be restored by a governor?
Yes, and that's a procedure that goes before what's called the pardon board. It's made up of the governor and the members of the cabinet. And you may apply for a pardon.
So how do they know?
If you get a pardon, then you can get your civil rights restored.
I got you.
And it's as if you were never convicted. Of course, Richard Nixon was never prosecuted, but President Ford granted him a full and complete pardon, which meant he could never be prosecuted. Okay.
Right.
But
how do we have this all the time? Do we have people who are felons every year applying for a pardon?
Well, I'm sure you do. I don't think that the governor and the cabinet freely grant those. I know of a couple of cases where they have been granted, but each case is different. Each case is weighed on its own merits.
I got you.
And you know, at some point, when has a person paid their debt to society?
Well, yeah, I'm not questioning. I'm just wondering how it's done.
If they've well, the procedure is to apply for a pardon to the governor, and then it comes before the pardon board, which is the governor and the cabinet, and they sit there and they get reports from law enforcement, from the Department of Corrections, from probation, from the prosecutor, from the victim, from the defense attorney, from any interested persons, letters from people in the community. Many people who have applied for a pardon will get prominent members of the community who are respected by the governor. If you're a big contributor to the governor's campaign fund and you have a relationship with the person seeking the pardon, your letter's probably going to get listened to a little bit more than some unknown John Doe citizen who writes the governor. And that's I'm not governor in general. I'm not referring to any particular governor, but politics being what they are, people of influence always have access to political a political dialogue, if you will. Doesn't mean the governor will do it, but it doesn't hurt if somebody who is well known, well respected, and that's not just because of power, money, or what have you. If the governor has a relationship with someone or the members of the cabinet and they trust this person's judgment, and a person they know says, I know this individual and I know that he is deserving of a pardon. It's kind of like the proverbial second chance, forgiveness, clean slate. And so it's there. I don't think there's ever been anyone who has. Well, I take that back. These sweeping statements always are not good. But you know, it is highly unusual that pardons are granted frivolously. I recall there was some criticism of one of the former outgoing presidents who at the 11th hour, yes, I believe that was who did it. There may have been others, but they were, you know,
I remember him.
He was sitting there literally before the stroke of midnight, signing pardons that later got questioned as being less than providently granted.
I remember that, and it was a talking point on the talk shows. So
I would imagine there's you know, the talk shows, you know, they certainly raise interesting issues. You know, several times we've kind of inadvertently morphed into political things. We've tried to stay away from that because this show's try to talk to people about the legal system and a generalized question of what they have. But, you know, it's very hard because so many times our legal system, the passing of laws, the acts of our legislature in drafting legislation certainly have political components, and we would be naive in this show or in any other forum not to recognize that the political component is a factor to be considered.
Well, and one big one is a law that, I guess, two laws that just went into effect yesterday. Today's only the second. The 14-day rule now if you're in an accident for PIP. And what was that? Oh, and the other thing about the flashing lights. You can now, I guess it's no longer illegal to flash your lights.
Yeah, well, the statute that they were using to prosecute that under, that was a little bit of a stretch that I think was pretty questionable, and it got challenged in court, and then they quit writing tickets on it. But the statute was that it is an offense to operate a motor vehicle with flashing lights. That was really designed to keep people from driving down the highway with their emergency flashers on. The theory behind that statute is that the emergency flashers are supposed to indicate to oncoming motorists that that vehicle is disabled and is stopped. And you will see so many people, I think, very improvidently driving down the interstate in a heavy rain with their flashing lights on, and it will almost have a stroboscopic effect and can really be dangerous to other drivers. Plus, you don't know whether the vehicle stopped. Well, you don't know whether the vehicle stopped or not. Well, it's been a violation. It's been a violation of the law, but they were trying to use that law to interpret that if you saw a law enforcement officer parked on the side of the road with a radar gun, and you went down the road and flashed your headlights just one time at your oncoming motorist, they were giving tickets for that. So I think that was a bit of a stretch for that law.
Gosh. Can I squeeze in one more real quickly?
I'll do my best.
There was another thing yesterday with the new year. There was a bill passed that goes into effect as of yesterday that provides safe places for children who are in need of a place. To pay for those safe places, they have raised the penalty on prostitutes, or maybe the Johns also, but there's a penalty it went from $500 to $5,000, and when you pay that penalty, $4,500 of that $5,000 goes to fund these safe houses. These safe places for children.
I'm not familiar with that law. I didn't read that. I need to read that law before I comment on it because depending upon what the offense is, if it's a misdemeanor, misdemeanors the highest fine for a misdemeanor is $1,000. So I don't know what offense that you would be referring to for prostitution or what have you, but if it's not a felony, the highest fine for misdemeanor is $1,000. So I don't know where they'd be getting $5,000 unless it's a felony offense.
Is prostitution a felony offense?
I don't know off the top of my head. I think that they are different degrees, and I think for a first offense, it is a misdemeanor. But there are different elements of it. I've never defended a criminal case involving that, but I think that if it's a conspiracy or racketeering or something like that, then it's a very serious offense. But I think initially it's a misdemeanor.
All right, so here's the joke. A guy goes to a prostitute, and it's his first time. And he's nervous, and he says, well, what do I call you? And she goes, well, it's your first time, so call me Misdemeanor. It's a joke. It didn't go very far, did it?
Well, I immediately picked up on it, and I totally understood exactly what you were saying, and I wouldn't want to hurt your feelings. It just wasn't
It just
funny,
wasn't
Larry.
that good of a joke.
No, it was a wonderful joke. You'll pull the plug on me over there.
All right, so the third time he says, what do I call you? You call me felony. You call me a felony.
There you go.
Right.
Now you're getting it.
That's good. John, how do we get a hold of you if we need to hire?
Okay, if you'd like to talk with us at our law firm, our telephone number in Ocala is 352-547-4292. Our toll-free number is 855-534-2565. We have offices in Ocala and the villages, and if we can help you, if you've been in an accident, or if you have a commercial or business issue or Social Security disability, don't hesitate to give us a call.
Definitely. All of the above, and I'm sure that as we enter the new year, there will be plenty of those. Thank you, John.
Thank you. Always fun.
Fun show. We'll take a little break and be right back.
Wow.
Ocala's information station, 1370 WOCA.
Ocala.
Weather is brought to you by myfwc.com. Life jackets save lives. We're at Florida. A warm day today with intervals of clouds and sunshine. High 76 to 80. Partly cloudy and mild tonight, though 58 to 62. Clouds and some sunshine and warm tomorrow. There can be an afternoon shower. The high 71 to 77. For Friday, clouds and some sunshine and a bit cooler. Highs the upper 60s. From the Florida Weather Center, I'm meteorologist Joe Lundberg.
We have Lena on the phone.
Hi, this is Lena with ABC Frederick's Appliance. We service all makes and models and warranty our work and our used appliances, from Maytag to Whirlpool, Crosley, and Speed Queen. So stop in at ABC Frederick's Appliance to see our showroom 1/8 of a mile from the tracks on County Road 25 in Bellevue, or call 347-2781. That's 347-2781. That's 1/8 of a mile from the tracks on County Road 25 in Bellevue. ABC Frederick's Appliance.
Great talking to you again, Lena. See you at ABC Frederick's Appliance.
By now, you know about the best fine dining Italian restaurant in Ocala, Messa di Notte. You already know that they have the best Italian cuisine made from scratch with only the freshest ingredients. But what you may not know is that you can get the same great food and professional service catered at your next event. Messa di Notte is incomparable to any other caterers with their professionalism and attention to detail. When only the best will do, call Steve at Messa di Notte, 502-5355. That's 502-5355. Messa di Notte.
Here's what you may have missed on the John Tesh Radio Show.
Internet addiction is real because it takes over sufferers' lives, costing them their savings, job, their relationships. And the only way for internet addicts to regain control is by getting professional treatment. The point is to not expect your partner to be everything in your life. That's a big mistake. When you're self-sufficient, you do add strength to your relationship because you don't depend on your partner to fill all of your emotional needs.
Intelligence for your life on the John Tesh Radio Show. Don't miss this stuff.
Ocala's